Imagine this. The place you call home, maybe it's not much, but it's yours. And then just like that, it could be taken away with a simple order. Now think about a legal system trying to grapple with not just property rights, but, the very essence of human dignity.
Exactly. That's really what's the heart of the case we're looking at today.
Right. Welcome to the deep dive. So today we're diving into a really significant South African legal case, Port Elizabeth Municipality versus Various Occupiers. We're going to unpack how this judgment really shifted the whole landscape around property rights and housing after apartheid.
And whether you're maybe studying law or you're just interested in how courts can actually drive social change, this case has some pretty surprising layers.
It really does. And you mentioned what's at the heart of it, this tension.
Yeah, it's this fundamental clash, isn't it? The traditional idea of owning property, your rights as an owner, versus this incredibly basic human right to have somewhere to live, a place to call home.
It sounds like more than just legal definitions.
Oh, absolutely. It's deeply human. The court had to navigate this with real care.
Okay, so let's start with that human story. We're in Port Elizabeth, South Africa. The municipality is the applicant, taking action against people they just term various occupiers. Who are these people?
Right. So we're talking about roughly 68 people, and that included 23 children living in about 29 informal shacks they'd built on land that was actually privately owned.
Okay. And how long had they been there?
Well, for quite some time, actually. It varied, but between 2 and 8 years for many of them. A lot of them had ended up there after being evicted from somewhere else previously.
So this wasn't their first experience with insecure housing?
Not at all. And they actually said, look, we're willing to leave, but you need to give us reasonable notice, and importantly, offer us suitable alternative land, somewhere else to go.
And the municipality did suggest somewhere, right? Walmer Township. But the occupiers weren't keen.
Yeah, they really rejected that idea. They described Walmer as crime-ridden, unpleasant, overcrowded, and they were really worried they'd just face eviction again down the line. No security.
So they wanted a guarantee of stability.
Exactly. Now, it's worth noting they hadn't formally applied for housing through the municipality system. But they weren't just disconnected individuals. Their kids went to local schools. The adults had jobs nearby.
They had roots in the community.
They did. They claimed they were using hygienic pit latrines, getting water from a nearby riding club. There was also this belief among them that they'd initially had permission from someone they thought was the owner.
Although the actual owners later denied that.
That's right. The landowners denied giving permission. So a bit of a gray area there on how they first arrived.
Okay, so that's the occupier situation. What was driving the municipality's actions? Why did they want to evict them?
Well, the catalyst seems to have been a petition signed by about 1,600 people, including property owners themselves, asking for the eviction.
So there was pressure from residents and owners.
Yes. And the municipality's main legal argument was essentially about fairness in the housing system.
Yeah.
They said providing alternative land specifically for this group would be queue jumping.
Queue jumping, meaning it would push them ahead of others waiting for housing.
Precisely. They argued it would disrupt their big, comprehensive housing development program. They felt legally they had no special obligation to house these particular people beyond just letting them register for their standard 4-peg housing program.
Which sounds like a very basic long-term solution.
Exactly, something that would take years. They also mentioned potential health risks from the lack of formal sanitation, although, as we said, the occupiers disputed that.
Okay, so this dispute ends up in court, but it didn't go straight to the top court, the Constitutional Court did it? What happened first?
No, it went through the lower courts first. The High Court initially found in favor of the municipality. They ordered the eviction, ordered the demolition of the shacks, basically saying it was in the public interest to stop the unlawful occupation.
Okay, so round one to the municipality, but it didn't end there.
No, it went up to the Supreme Court of Appeal, the SCA, and the SCA actually overturned the High Court's decision.
Really? What was their reasoning?
The SCA saw it differently. They said the occupiers weren't really asking for special treatment in the housing queue. What they were seeking was secure tenure, a place to live without constant fear of removal.
So focusing on the security aspect.
Yes, and a key factor for the SCA was whether suitable alternative land was actually available, especially because the entity pushing for eviction was the municipality, an organ of state. The SCA felt it wasn't clear if the proposed place, Walmer, was even municipal land or if any security of tenure was actually guaranteed there.
So the SCA sided with the occupiers and set aside the eviction order.
That's right.
But the municipality still wasn't satisfied. They took it further.
They did. They appealed the SCA's decision to the highest court, the Constitutional Court. And their specific goal was to get a ruling saying, basically, that they were not constitutionally required to provide alternative accommodation or land when they were seeking an eviction like this. They wanted clarity on that obligation.
Okay, so the stage is set for a major constitutional showdown. But to really get why this case was so huge, we need to understand the context, right? The history of land law in South Africa before democracy.
Absolutely. You can't understand this case without looking back at the dark shadow of apartheid land laws.
What did things look like then if someone was occupying land unlawfully?
It was brutal and simple. The main law was the Prevention of Illegal Squatting Act of 1951 PIS.
Yeah.
If your occupation was deemed unlawful, that meant summary eviction. You could even face criminal charges.
Criminal charges, just for trying to find somewhere to live.
Yes. Eviction was handled through the criminal courts. It was a public law thing, designed to be fast and harsh. There wasn't much room for arguing your case.
And PISA wasn't an isolated law, was it? It was part of a much bigger picture.
Oh, definitely. PISA was integral to a whole cluster of infamous apartheid laws. Things like the Natives Land Act of 1913, the Group Areas Act of 1966. The entire system was designed to systematically dispossess Black South Africans, push them off land, and force them into racially segregated areas.
There was that saying, wasn't there? Dispossession was 9/10 of the law.
Exactly. And it made urbanization incredibly racialized. These laws were about controlling Black people's movement and presence, especially in urban areas.
What's really disturbing is how even standard legal ideas about property ownership were used to justify this.
That's a critical point. Even seemingly neutral principles from Roman Dutch law, the common law system South Africa uses, which strongly favors owners' rights, even those were sort of bent and used to legitimize the awful outcomes of these racist laws.
So the law itself became a tool of oppression.
Without a doubt. It meant that Black shack dwellers, people just seeking shelter, were hit with dramatically harsh effect, as the court later put it. The legal system basically rubber-stamped the removals needed for apartheid spatial planning.
A truly grim picture. So fast forward to the new South Africa, the democratic era. How did things start to change?
Well, a massive change came with the new constitution, and specifically with the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act of 1998. We call it PIE.
PIE. Okay, and how did PIE differ from the old PIS?
It wasn't just a repeal. The court said it effectively inverted PIS. Firstly, squatting was decriminalized. That's huge. And secondly, any eviction now had to meet strict requirements directly linked to the new Bill of Rights.
And even the name changed, right? From illegal squatting to illegal eviction? That seems significant.
Hugely symbolic, yes. The focus shifted completely. It wasn't about punishing squatters anymore. It was about preventing illegal eviction, protecting vulnerable people. PIE brought in strong procedural and substantive safeguards.
So it moved away from just displacing people.
Yes. It acknowledged the reality of people's necessitous quest for homes, as the judgment says. It demanded they be treated with dignity. And the courts, their role changed fundamentally. They weren't supposed to be instruments of callous removals anymore. Instead, they were tasked with carefully balancing the rights involved, the owner's rights, against the occupier's situation, aiming for justice and equity in every case.
And what's the constitutional foundation for PIE? What core values are driving this?
It all comes back to the foundational values of the South African Constitution: human dignity, equality, and freedom. Those are the bedrock.
Okay. And how do specific rights, like property and housing, fit in? Let's start with Section 25, property rights.
Right. Section 25 is interesting. It does protect property rights, absolutely. That was important to counter the past disregard for those rights, especially for Black people. And this is crucial, property rights are not absolute.
Not absolute. How so?
Well, subsections 4 to 9 of Section 25 specifically talk about the need to redress the massive inequality in land distribution caused by apartheid. So property rights are subject to broader societal needs, particularly the need for social justice.
So it's a different view of property.
It's a much more dynamic public law view. The Constitution is seen as a tool for social change, for transformation. Property isn't just a private right, it also has to serve the public good. It's like property rights with a social conscience built in.
Okay, that's property. Then there's Section 26, the right to housing.
Yes, Section 26 guarantees everyone the right to have access to adequate housing. And very relevant here, it says, no one may be evicted from their home without an order of court made after considering all the relevant circumstances.
All relevant circumstances. That sounds broad.
It is. And the court really emphasized what a home means. It's not just bricks and mortar. It's a zone of personal intimacy and family security, especially for the poor. Being forcibly removed is a profound shock.
It's about the human impact, the dignity aspect again.
Exactly. The judgment says society itself is demeaned when state action intensifies rather than mitigates their marginalization. So, Sections 25 and 26 work together. Land rights and housing rights are closely intertwined.
So the Constitution wants orderly reform, not land grabs, but it puts strong protections against arbitrary eviction.
Precisely. Section 26(3) gives people those defensive rights. And the court's job isn't to automatically favor the owner or the occupier. It's to balance out and reconcile the competing claims justly, looking at all the interests and the specific facts of that particular case.
Okay, so that brings us to the heart of PIE, this just and equitable test. How does it work in practice, especially when it's the state, like the municipality, wanting to evict someone?
So Section 6 of PIE deals with evictions by organs of state. The state needs to show certain things first, like the occupation is unlawful, maybe the structures are unauthorized, or there's a public interest reason like health and safety.
But proving those things doesn't automatically mean eviction.
No, that's the massive shift from the PISA days. Proving those facts just triggers the court's discretion. The court may grant an eviction, but only if it is just and equitable to do so after considering everything.
So just and equitable is the real hurdle. What factors does the court have to consider under Section 6.3?
Okay, there are three main factors listed that the court must consider. First, the circumstances of the occupation. How did they end up there? Was it desperation? Did someone maybe give them a nod, even if unofficially? Is the land public or private? Is their presence blocking some essential housing project?
Right. What's the second factor?
Second, the period of occupation. How long have they been there? The longer people have lived somewhere, built lives, integrated kids in school, jobs, social ties, the stronger their claim for the court's protection becomes. The court said it would be more cautious about evicting well-settled families. It's not about gaining legal ownership through time, but about basic fairness.
And the third one, this seems like the big one in this case.
Yes, the third mandatory factor is the availability of suitable alternative accommodation or land. Now, the court was clear. This isn't an absolute inflexible requirement in every single case.
Okay. So the municipality wasn't strictly wrong in saying there wasn't an absolute duty.
Well, not an absolute duty in all circumstances, perhaps. But the court immediately added that courts should be reluctant, very reluctant to order an eviction if there isn't a reasonable alternative available, even just as a temporary interim measure.
So while not absolute, it's a very, very weighty factor.
Extremely weighty.
Yeah.
It's about finding a suitable option somewhere people can go without facing intolerable hardship and doing it without unfairly disadvantaging others waiting for housing. It demands flexibility from the state, not just pointing to a long-term plan years down the road.
Got it. So circumstances, duration, and alternative accommodation are the must-considers. But you said the court's mandate was even broader.
Yes, the Act says the court must consider those three and all the relevant circumstances. The court stressed this gives it a very wide mandate.
What else could fall under that?
All sorts of things. Vulnerabilities are there? Elderly people, children, people with disabilities, women heading households. What offers were made, if any? How reasonable were they? How did the occupiers respond? Did they engage? The court said each case is extremely intricate and needs a nuanced appreciation.
So the court needs the full picture.
Absolutely. It must be fully informed, and the judges might even need to look beyond what the parties formally present to make sure justice is done.
This just and equitable standard sounds like it requires more than just applying legal rules.
It really does. The court said it requires judges to break away from a purely legalistic approach. They have to consider morality, fairness, social values, and implications. It's about actively managing a social situation, infusing elements of grace and compassion.
Grace and compassion. That's quite striking language for a legal judgment, and this is where Ubuntu comes in.
Exactly. The court explicitly mentioned the spirit of Ubuntu, that deep African philosophy emphasizing humaneness, personhood, group solidarity, compassion, respect, human dignity, collective unity.
How does Ubuntu connect to the legal process?
The court said Ubuntu suffuses the whole constitutional order. It pushes towards recognizing our interdependence, treating each other with respect and concern. It reinforces the idea that the law, especially in eviction cases, should be humane.
Given that emphasis on humanity, complexity, and finding solutions, mediation seems like a really logical step. How did the court view mediation?
Very positively. They strongly encouraged it as a more dignified and often more effective way to find sustainable reconciliations.
What are the benefits they saw?
Well, it's usually cheaper than long court battles. Crucially, it avoids hardening positions and making tensions worse, which adversarial court fights often do. And mediation can find creative solutions that a judge might not be able to order.
So forcing people to talk, basically.
Forcing them to participate in the process, yes. Not forcing a settlement, but compelling them to sit down and try to find common ground. And the courts stress the importance of how people are viewed in this process. Those wanting the eviction, like the municipality, need to avoid stereotypes, seeing people as faceless and anonymous squatters. Justice demands seeing everyone as an individual bearer of rights.
And the occupiers.
They also have a role. They should use their own resourcefulness to find solutions, engage constructively. It's a two-way street.
And mediation feels particularly relevant in South Africa.
Definitely. The court highlighted its importance in a country trying to heal from deep historical divisions, saying it promotes respectful, good neighborliness.
Did they lay down any specific guidelines about mediation?
Yes, a very important one. The court stated that, absent special circumstances, it would not ordinarily be just and equitable to order eviction if proper discussions and where appropriate mediation have not been attempted.
Wow. That basically makes trying mediation almost a prerequisite for eviction unless there's a very good reason not to.
That's the strong implication, yes. It puts a heavy onus on parties, especially organs of state, to genuinely try to talk first.
But didn't you say mediation wasn't ordered in the specific Port Elizabeth case? Why not, given how strongly they felt?
That's right. The court considered it, but decided against ordering it at that late stage. They felt too much time had gone by, the legal battle was already intense, and neither side seemed fully committed to mediation at that point.
Okay. But the fact it hadn't been tried earlier still matter?
Oh, absolutely. The court explicitly said the failure to attempt discussions or mediation before going to court was an important factor weighing against granting the eviction. It was a clear signal for future cases.
Okay, so we have the history, the constitutional values, the PIE framework, the just and equitable test, the emphasis on mediation. Let's bring it back to the specific facts. How did the Constitutional Court apply all this to the actual situation in Port Elizabeth?
Right, they went back through the facts, applying this new lens. They highlighted the length of occupation, 2 to 8 years. These weren't fleeting occupants. Kids were in local schools, adults had local jobs, they were settled.
What about the land itself?
Crucially, the court noted the land was vacant. Neither the private owners nor the municipality seemed to need it for any specific productive purpose at that time. There was no urgency.
And the municipality's interaction with the occupiers. How did the court view that?
Not favorably. They pointed out the municipality had done nothing for years about the occupation, and then suddenly acted precipitately by launching legal action. They found the municipality took only cursory steps to understand the occupier's real situation.
So not enough effort to engage before suing.
Exactly. No attempts to seek to address the problems before going to court was the finding. And the court pushed back hard on the queue-jumping argument.
They didn't buy it.
No. They saw the occupiers not as trying to cheat the system, but as genuinely homeless and in need.
And the big one, alternative accommodation.
The court found the municipality's proposals, Walmer, Greenbushes, were unsuitable. And they noted the municipality just ignored the occupiers' own suggestions, like Seaview or Fairview.
And the municipality just stuck to their position of having no duty.
Pretty much. They bluntly asserted no duty beyond their long-term program. The court identified the central failure as the municipality's refusal to seriously consider or at all the request of these occupiers that they be provided with suitable alternative land upon which they can live without fear of eviction until provided with housing.
So weighing all of that, the long occupation, the vacant land, the lack of engagement, the failure on alternatives, the genuine need, what was the final decision?
Taking everything into account, the Constitutional Court concluded it was not persuaded that it was just and equitable to order the eviction in these specific circumstances.
Not just and equitable. So the eviction was off the table.
Correct. The municipality's application for leave to appeal was formally dismissed with costs.
Which means the SCA decision, the one that overturned the original eviction order, was the final word.
Exactly. The SCA decision stood. No eviction.
Wow. This deep dive really makes it clear. Port Elizabeth Municipality v. Various Occupiers is so much more than just one case about one group of people.
Oh, absolutely. It fundamentally shifted the understanding of property rights in South Africa. It moved away from that old, almost absolute common law idea of ownership.
Towards something balanced with dignity, social justice, the right to a home.
Precisely. And it placed a real active responsibility on the state, on municipalities.
A duty to engage meaningfully.
Yes, to genuinely explore alternatives, to consider mediation, to treat people humanely before even thinking about eviction. It demands a proactive, equitable approach, not just relying on the cold letter of the law.
It's a powerful judgment. So as we wrap up, here's something to think about. What does it really take for a society, for its laws and institutions, to truly reflect that grace and compassion, that spirit of Ubuntu, especially when dealing with these incredibly tough human issues of land, homes, and dignity for absolutely everyone?
That's the enduring question, isn't it? How do we make those constitutional values a lived reality on the ground?